Hello and welcome to the River Rock Law YouTube channel. My name's Jennifer Locke and I am a wills and estates and real estate lawyer in Edmonton, Alberta. And I've created this channel just to help give some tips and tricks when it comes to estate planning and, of course, wills and estates matters. So the one that I wanted to talk to you today about is 3 things that you need to figure out before you meet with a lawyer. And the intent of this is not, of course, to make it more difficult for you to actually go forward with your estate planning, but quite often, especially couples are usually caught off guard with some of these things that they have to consider. But if you're able to have these discussions prior to meeting with the lawyer, you should have no problem at your intake when they take your instructions, okay? So the first thing that usually we talk about, especially of course if you have children or maybe you're planning to have children, is who's going to be your guardians of your minor children. So sometimes this is fairly easy for couples, but other times they struggle. So things that of course that couples should take into consideration when appointing guardians, and of course this is in the case that both parents have perished, is who has similar values and beliefs. Who do you think would make a good parent? Who has kind of that energy level? Of course, your estate is going to be used to take care of your children, meaning that the funds from your estate can be used to pay extracurricular activities, clothing, trips to the dentist, etc., that sort of thing. So we're not so much worried about that component, but if you're thinking about naming, for example, your parents and they have significant health issues, they're quite elderly, they may not be the best choice to act as guardian. Same thing if you have, of course, family members that have children that are phenomenal parents. Maybe they have 4 children that are quite young, and so taking on additional children to care for might be a bit of a stretch. So I encourage you to have those discussions with your spouse and just take some of those things into consideration when you're naming your guardians. The next thing, of course, is naming your beneficiaries. And so one of the things that people often end up kind of thinking, well, shouldn't that be straightforward? I mean, if I have my spouse, it's going to be my spouse. And if I have kids, it's going to go to my kids if my spouse predeceases me. And yes, that's correct. But when we're dealing with people who, say, for example, are elderly and only have 1 adult child and there's no grandchildren, well, God forbid that adult child predeceases the client, where does the money go? So that's why it's important to consider a disaster clause. Same thing if I'm dealing with a young couple that has children. As morbid as this example is, it can happen. What if you're all on a plane, and mind you, it's the pandemic, so hardly anybody's traveling, but one day when we can travel again and there's a horrific plane crash? Who's going to end up getting the money if your spouse, you, and your children have all died in this common accident? Are we going to split it 50-50 between your spouse's surviving parents and your surviving parents? Is it going to go between all your surviving nieces and nephews, siblings? So again, that's a really important consideration to think about. And then, of course, the last thing that I kind of touch base on, of course, is the ages for distribution of minor children. So unless you say otherwise, your property is going to be transferred to your children in the event that you die before they become adults when they turn 18. And if you have some fairly significant life insurance policies, this may not be a great idea. So if you and your spouse, or perhaps you're a single parent, and you're insured for $1 million and you have 2 children and you pass, well, unless you state otherwise, those kids are going to be coming into that money when they turn 18, subject to some insurance policies have quite sophisticated provisions saying, okay, well, let's not pay this money out until X. But that's not all the time. And so that's why it's important to kind of check with your insurance provider to make sure you know kind of the terms that you set up when it comes to minor beneficiaries. What I like to do instead, and a number of wills drafters like to have this conversation, is discuss what a more perhaps appropriate age is to inherit a lot of money. Because that's a lot of money for a young adult to get, right? And so we want to make sure that they're mature enough to handle it. So maybe instead we do a little bit of money, a little bit of a payout when they're 18 or even 21. Maybe we then do a next larger distribution when they're 25, final distribution when they're 30. It really depends, obviously, of course, on the assets that you have, and also, of course, on the maturity level of your beneficiaries. Some of which you may know, maybe they're in their teens and you can kind of guess what they're going to be like, but some of you might not have children yet. You're planning to. You haven't even met them. So how can you guess what they're going to be like spenders? Some of them are 4 years old, right? So those are things to think about. So those are kind of the three biggest areas that people struggle with. So if you have any questions or you want further ideas or comments below, feel free to provide them about what you'd like to see for YouTube content, wills and estates questions that you have. I'm happy to, of course, give general information because, again, this is just that. It's general information for specific legal matters pertaining to your exact situation. Please reach out to legal counsel, whether it's myself or another lawyer. I'm more than happy to direct you in terms of what's going to make an appropriate and worthwhile solution for your estate planning needs. So, thanks so much. Everybody have a great day and hope to catch you next time.